Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm is a primary focus on family law issues here in Michigan. We provide a lot of education through our video series that answers not only generic questions that have come up over the years, but specific questions of clients. So therefore, please subscribe to our channel. We had a question about guardianship and whether or not grounds to switch the guardianship might be that the guardian doesn't visit the person in the hospital during an extended hospital stay, and perhaps somebody else does, and now they want to be the guardian. Can that be a reason to switch? Well, I'll tell you, generally, in and of itself, that's not going to be a reason to switch. I mean, the role of the guardian is to make sure that the ward's needs are met. It may or may not include going to the hospital to find out about medications, to talk to the doctors, to find out certain health things, but it doesn't really have a strong social component. Visiting the patient is a family thing. It's a nice thing to do. It would be great if the ward was a family member and did that, but that's not going to necessarily be a disqualifier in the face of doing the other things that are necessary to make sure that the ward is well taken care of and the ward is comfortable. In other words, if a person is not the guardian but goes to see the ill individual every day in the hospital, and the court-ordered guardian does not, that in and of itself is not going to be a disqualifier for them and a qualifier for you. The court has to look at a much broader picture when determining guardianship and has to determine that the overall needs of the person are going to be met. In other words, if the guardian is making sure that the person's in a good facility, making sure that all the bills are being paid, making sure that the person's medications are spot on and that they're being taken and that they're properly regulated and all that, you know, those are going to be very significant things that support the guardianship. Whether he or she socializes with the guardian, you know, that's great, but that's not going to carry the day in the face of the other things. Flipped around, if you do none of those things, but you visit the sick person every day, that doesn't necessarily qualify you to be a guardian. So you see, there's a much broader picture involved that the court has to consider. A lot of times, the court will appoint as the guardian an agency. They don't even know the person personally. They'll appoint an agency over family. And you can say, well, the agency's not going to care to visit this person. The agency's not going to care about the individual. That may be, but the agency will make sure that the general stuff is done. The bills are paid, the proper doctors, proper facility. That's what they'll take care of. And so a lot of times the court feels that ultimately, in terms of bigger picture, that's what's most important. Obviously, every case is different, and your case may have a different fact circumstance that dictates a different result. If you have questions about that, reach out, and we'll be glad to help you out.